This is the appointed time. We have a quorum. This is the joint meeting of the Panel on Security and Panel on Administration of Justice and Legal Services. Item number 1, election of chairman. As per the request of the administration and with the consent of the chairman, Mr. Lam San Keung, Chairman of the Panel on Security, Mr. Lam San Keung, and myself, Chairman of the Panel on Administration of Justice and Legal Services, we agreed to hold this meeting. With the consent of Mr. Lam, I will convene this meeting. In accordance with relevant regulations, if members don't have any objections, I will chair this meeting. Any objections? No. Item number 2 then, making of subsidiary legislation for safeguarding national security. I now ask the Secretariat to invite the administration to come in. We have with us in this discussion Mr. Paul Lam, Secretary for Justice, Mr. Chris Tang, Secretary for Security, Mr. Llewellyn Mui, Solicitor General, Department of Justice, Mr. Benjamin Mock, Deputy Secretary for Security. I will dispense with the introduction of other team members. This is in relation to a legislative exercise, so other members are invited to join the discussion. We have paper CB bracket 2881 of 2025 bracket 01. The paper was sent to members this morning. Mr. Paul Lam, Secretary for Justice, and Mr. Chris Tang, Secretary for Security. I welcome you and your team. I'll first ask Mr. Lam and Mr. Tang to take us through the paper. Members, please press the request to speak button. Secretary for Justice. Thank you. First of all, I'm grateful for the Panel on Security and Panel on Administration of Justice and Legal Services for arranging this joint meeting for the administration to have a chance to present the making of subsidiary legislation for safeguarding national security to members. Well, with the concerted efforts of the administration as well as different quarters, on the 19th of March 2024, we have the Safeguarding National Security Ordinance, and it came into operation shortly afterwards. We have fulfilled our constitutional responsibility. Relevant legislations, including the Ordinance, the National Security Law, and other regulations, have put in place a very robust safeguard mechanism for security. There is the 28th of May decision, an MPCSC decision according to Articles 3 and 4. We have the constitutional duty to continue to improve the legal system and enforcement mechanism for effectively safeguarding national security, to continue to prevent, suppress, and punish acts and activities endangering national security effectiveness. The subsidiary legislation is authorized by the executive to formulate implementation details and administrative measures. The administration will continue to review various matters. This is an established mechanism under the national security law as well as the basic law. Risk of national security can come at any time. It's unpredictable. So the administration has to dovetail the work with the executive authorities to specified implementations. In the scrutiny of the Safeguarding National Security Ordinance, we have taken into account members' views. We have added a section 110, which means that the CN Council can make a subsidiary legislation on implementation details in accordance with the MPCSC's interpretation as well as relevant regulations and laws. The job is to formulate, implement details to effectively implement relevant regulations. The power of the executive is restricted. First of all, subsidiary legislation should be confined to the main principle and should not go beyond that scope. Section 28(1)(b) of Cap 1 clearly stipulates that subsidiary legislation should not contradict to any other provisions in any other ordinances. Section 34 of Cap 1 dictates that subsidiary legislation of this kind is subject to negative vetting. The LegCo may make amendments in accordance with Section 110 of the Ordinance to make subsidiary legislation because we want to fulfill our constitutional duty. That is in relation to Cap 5, that is the mandate of the Office of Safeguarding National Security. We need to formulate implementations to improve the mechanism. The office is an indispensable part of the central authorities level and the SAR level. The mandate of the office is to have oversight and guidance of Hong Kong SAR Committee, and in relation to the three types of circumstances, they have jurisdictions over national security cases. There is a clear delineation. We want to effectively provide for various matters in relation to their duties and functions. At the same time, under Section 40, under Article 42, under Section 42, that is, the CE may declare a place as a prohibited places. We have drawn reference from the UK National Security Law 2023 and the Public Order Ordinance and other ordinances. We want to designate certain places as prohibited places to stop unauthorized entry. This is also a piece of subsidiary legislation that is subject to negative vetting of the LegCo. Our proposal is fully in line with the Basic Law as well as the National Security Law. In relation to the rights and functions of the office, there are strict restrictions. The purpose of this exercise is to put in place provisions under Chapter 5. There is no new power given to the office. When staff of the office request assistance, they have to act in accordance with the law, and the request should be proportionate. In relation to the offences in the subsidiary legislation, we have drawn reference from existing similar offences in other ordinances. There are also defences as well as exceptions, so organizations and individuals will not be caught inadvertently. I will now defer to the Secretary for Security to go over the salient points of the legislative exercise. Afterwards, we'll be happy to listen to members' views and answer questions. Thank you. Now we hear from the Secretary for Security. Thank you. Before I go into the salient points, I would like to emphasize a few points. First, Chapter 5 of the National Security Law stipulates the mandate of the office, which is to have oversight, guide, and coordinate the Hong Kong SAR in fulfilling its duties. And under Article 55, that is in relation to the three specified circumstances, that is, the case that is complex due to the involvement of foreign country or external elements thus making it difficult for the SAR to exercise jurisdiction. 2, a serious situation where the Hong Kong SAR government is unable to effectively enforce the law. And C, a major and imminent threat to national security has occurred. And in relation to the 4 offenses, that is, act of cessation, subversion of state power, terrorist activities, and collusion with foreign or external forces. It's only under these circumstances that the office will take jurisdictions of these cases. The purpose of making the subsidiary legislation is to, on a local level, specify implementation details to give effect to these matters so that the office can effectively perform their duties. And the national security law has provided strict provisions in relation to the powers and functions of the office. The proposed legislation will not confer additional power to the office or their staff. There will not be additional functions given to the office and its staff members. It will not affect the normal lives of Hong Kong people. Should there be circumstances under Article 55, then the central authority will have to give an approval before the office takes jurisdiction of the offences I have just outlined. That is in relation to the 4 types of criminal acts. That is in relation to cases of a serious and egregious nature and involves a significant impact. We think the likelihood of these cases is low. However, Hong Kong SAR should be prepared and put in place an effective mechanism to support the office when necessary to perform the duties set down under Article 55 and to make offences to prevent, suppress, and impose punishment for the offences that is under the jurisdiction of the office. And in order to ensure that the office and its staff members will receive all necessary and reasonable assistance, facilitation, support, backing, and protection, we propose that in the subsidiary legislation, the Hong Kong SAR departments and agencies will have the duty to provide these assistance facilitations measures. And in relation to impersonating staff members of the office or forgeries of the documents of the office, they will become offences. We have drawn reference from existing offences in Hong Kong, that is, impersonating a public officer or police officer or forgery. Now I will go over the 4 areas. The first is in relation to the oversight and guidance of the office. Under Article 49 of the National Security Law, the mandate of the office includes overseeing and guiding the SAR in the performance of its duties for safeguarding national security. Article 53 of the National Security Law provides that the office shall establish a mechanism of coordination with the committee, that is, Committee for Safeguarding National Security of the Hong Kong SAR, to oversee and provide guidance on the work of safeguarding national security. In order to make sure that different departments, agencies, or public servants will understand their duties and functions, we propose to provide for the description of the mandate of the office in relation to overseeing and guiding the Hong Kong SAR in the performance of their duties. The second part is in relation to the effectiveness of carrying out investigations and carrying out acts in accordance with the law by the office. We propose that in the subsidiary legislation there are the following provisions. That is, when the office takes over jurisdictions under Article 55, Hong Kong SAR departments, agencies, and public servants will have to, in accordance with the request of the office, provide all necessary and reasonable assistance, facilitation, support, backing, and provision. Secondly, if there is no reasonable excuse, there is a failure to compliance with the legal documents issued under Article 55 of the office, it is an offence. We will also incorporate a usual immunity from civil liability to ensure that organizations and individuals, when acting in good faith in compliance with the legal documents issued by the office, there is no risk of civil liability. And fourthly, in purported compliance with the legal documents, it is an offense to provide misleading or false information. And without reasonable excuse or lawful authority, if investigation information of the office is disclosed, it is an offense. The other area is in relation to the performance of mandates by the office. In order to implement the relevant provisions under Chapter 5 of the National Security Law, we make the following proposals. First, in the performance of duties by the office, departments, agencies, and public servants of the Hong Kong SAR government should provide all necessary and reasonable assistance, facilitation, support, backing, and protection in accordance with the law and in a timely manner. Secondly, identity document certifications by the office, as well as the performance of duties by their staff members, these documents will have a legal effect. The other type of a new offense is willful resistance and obstruction of the office or their staff members, and willful resistance and obstructions by others in assisting the office. The other offense is in relation to forging of documents of the office. We also put in place the duty to keep confidential information of investigations carried out by the office, and that no one should possess or obtain or disclose such information unless the office makes the information public or has given lawful authority. And the fourth area is to declare certain premises of the office as prohibited places. Under Section 42 of the Ordinance, the Chief Executive may declare a place as a prohibited place. These matters in relation to the use of the place, the owner-occupier of the place, or the nature of any information in relation to the place. If the Chief Executive is of the view that there is a need to safeguard national security, they may declare the place as a prohibited place. It will be done by order published in the Gazette. Certain premises where the office performs its mandate will be declared as a prohibited places, but it will not involve private residence, and it will not cause any unreasonable impact on the community. It is necessary to safeguard national security for prosperity and stability of Hong Kong. So we welcome members' views in relation to the subsidiary legislation. At present, there is complicated geopolitical situation. There is always the national security risks. So it is better to put in place an effective mechanism as soon as possible. We will announce the details as soon as possible, and also we will gazette the two pieces of subsidiary legislation. We'll publish it in the Gazette and table them at the LegCo for negative vetting.
Thank you for the presentations by the two secretaries. So Article 110 was adopted by the SAR government in response to the request. We're going to have a meeting until 4:30, and a total of 22 members have indicated that they'd like to speak. I may not be able to allow all of you to speak, but I hope that you'd make use of the 3 minutes that would be given to you for both questions and answers. I'll read out the names of the first 10. And for the rest, you will have to contact the Secretariat first. Mr. Jimmy Ng, Benson Lok, Chen Hekan, Yen Wing Kit, Dominic Lee, Eunice Yong, Tan Ka Biu, Priscilla Leung, and the 10th would be myself. So, Mr. Jimmy Ng, 3 minutes for both questions and answers. Para 22 of the paper proposed that we will have to make reference to other pieces of legislation, so that for those who willfully resist or obstruct the discharge of mandate by the office, and also obstruction or of the obstructing the office in the performance of a duty and willfully resisting or obstructing others in assisting the office in the performance of a duty. It's hard to draw a line as to where is unlawful to do certain things, but of course you can also make reference to the legislation, and you should have a good idea as to what is unlawful, and that should go a long way in addressing public concerns. So can you elaborate a bit further on the words obstructing the office in the performance of its duty? Well, I'll attempt to answer the question and see if my colleagues have anything to add. Well, as you said, the word obstruction, if you take it out of context, it might be very abstract, but then we are not talking about anything new. For example, there are other laws, including obstruction of the police in performing its duty and so on. So we can just adopt common sense in interpreting this. And also when it comes to criminal liability, definitely we will have to look at the mens rea of the person. Have you done it deliberately? And definitely there would be very clear delineation of responsibilities, and also the mens rea will have to be clearly defined, whether or not there is an intention to commit an offense. And therefore there is no question of people committing an offense inadvertently, because that has nothing to do with mens rea, because in ordinary sense that would not be the case, and therefore I don't think there needs to be any worry about this. So long as you can act with common sense, it's okay. Any further follow-up? Thank you for the reply. Well, of course, for a legal officer or judicial officer, of course, that would be clear. But then members of the public will have to be reassured that this is nothing new. Indeed, if you look at our past history of more than 100 years, definitely you will understand what would constitute an obstruction of the carrying out of duty, and therefore there should be no cause for concern. Next, Mr. Benson Look, I fully support the subsidiary legislation to be enacted under the NSL. In fact, the business sector has been very supportive of protecting or safeguarding national security, because if Hong Kong is in chaos, then there is no way that we can do good business. And therefore, if Hong Kong is stable and prosperous, then we will be able to enjoy a very good business environment, and then we'll be able to do good business. And all along, with regard to safeguarding national security, well, we have all along taken a proactive approach in understanding the law, and also we have worked very hard to fully support this. But then can you explain to us, with regard to the SAR government's working together with the business sector in promoting our economic development, how we can create an even better environment for the businesses to operate? That's the first question. Secondly, with the subsidiary legislation, indeed, we'll be able to provide facilitation, support, and also protection to the office in carrying out its mandate. And in fact, in enforcing national security, those would be necessary. And as you said at the beginning, other than coming up with subsidiary legislation, are there other ways to achieve the same purpose? For example, can we have some administrative mechanism to deal with similar situations? So has the SAR government talked to the office as to what other ways and means could be put in place in order to achieve the same effect? So who will answer the question? Well, let me try. As to how the business sector can be better assured that there will be an even better operating or business environment, I think a couple of issues can be mentioned here. A stable environment is the premise for any business to operate. In fact, what we have been doing is to try and ensure that we will continue to perfect the national security mechanism and the enforcement mechanism. If we are able to safeguard national security, the better that we can do, the more stable the environment will become. And definitely such an environment will be conducive to businessmen doing their business, and they will have greater confidence in operating here. And secondly, for it, in the business sector, definitely they would love to see certainty, and therefore one of the ultimate objectives of this piece of legislation is that, well, for the concrete details that we are aware of, we hope that the we hope that the public as well as all the stakeholders will know very clearly as to what they should do and the consequences of doing certain things and so on. So by enriching the mechanism and also the legislative details, that would enable the public to have an even clearer idea as to what the system is about, and that would also provide for greater certainty. And therefore, to the businessmen, they should have greater confidence in the law. As to what other things can be done, well, of course, our constitutional duty is to continuously perfect the system. And of course, what we do today is part of the work, but then it's not the end of it. So it's a continuous situation, and therefore, so long as there is a need or a need arises, then whenever necessary, we will come back again. But then today, we'll focus on what we are dealing with in a paper. Thank you. Okay, Mr. Hacken Chen. Madam Chair, I support the SAR government in coming up with this piece of subsidiary legislation under the HKNSL that would ensure national security for our country. The central authorities have set up this mechanism for the purpose of safeguarding national security, and therefore the office will be providing guidance to us, and therefore that is its mandate because it's the constitutional duty of us in ensuring national security. I can see that in para 12 of the paper, it says that to ensure that in order to make clearer the CNSS role in making an overall plan of and coordinating the implementation of the office's oversight and guidance among various agencies and organizations and so on and so forth. So we will have to ensure that we will have to accept the opinions provided by the office on overseeing and guiding the HKSAR's work on safeguarding national security. Any government agency and public officer will have to provide timely facilitation and support to the office in implementing or discharging its duty. So the legislative direction is that it's going to be a top-down approach. That is, whatever the office asks us to do, then we will have to comply. So that's the way how we help or assist the office. So it appears that the ASEAN government will be very passive in doing this because apparently every public officer and every member of the public would have this duty to ensure national security. And how can we be more proactive in assisting the work of the office in implementing its monitoring work? Can we do that by way of the subsidiary legislation that is being proposed today? So can it be spelled out more clearly so that for public officers discharging their daily duties, then they would also have a very good idea as to how they can proactively work with the office in ensuring national security, or how they could prevent giving rise to national security risk. And if that can be spelled out in very expressive terms, then that would also be helpful to ensuring national security. On top of that, that would also be in line with the spirit of the subsidiary legislation. That's the first question. And the second point is, according to the administration, well, on the day of the Gazette, so all the subsidiary legislation will come into effect. So I'd like the government to explain to the public, why does it have to be so prompt? Why does it have to come into effect right away as soon as the Gazette is made? Two questions. So let me try and answer the question, and then the Secretary for Justice can supplement. Well, for the subsidiary legislation that is going to be enacted, the purpose is to assist the office to better discharge its duty under Article 55, and also under circumstances how we can further assist it in discharging its duty. It's not to emphasize the government's duty under the law, because indeed under Section 8.3 of the NSL, it already spells out that the ASEAN government has the duty of safeguarding national security, and also through the civil service regulation and also the code of conduct that has already spelled out what we have to do in our daily work to ensure national security is safeguarded. So we do that by way of those pieces of legislation and codes. Then why does it have to come into effect on the day of Gazette? Well, because of the international circumstances, the situation is very tense. And a simple example is that 2 weeks ago, the CIA of the US already targeted our country, and they publicly announced that they would be recruiting traitors. And therefore, in the face of national security, in fact, the situation is very tense, and therefore there could also be circumstances arising out of the blue, and therefore we will have to act preemptively to ensure that I will be able to do an even better job in terms of safeguarding national security.
I would like to supplement in terms of legal basis. Well, we all need to understand that this is not an exception to have the subsidiary legislation coming into operation on the date of Gazetto. If you refer to Section 28 of 3 of Cap 1, it says that subsidiary legislation is to come into effect on the date of Gazetto. So there is a general principle in place. Just now, the Secretary talked about an actual situation. In addition, there is the constitutional duty that Hong Kong SAR has to continuously fulfill. Of course, it is better to fulfill such duties as soon as possible. So on a practical level and on a legal aspect, we need to do it as soon as possible. Next, Mr. Kitson Young. The global situation is getting complicated. We should not neglect any risks to our national security. We need to perfect our legal system and implementation mechanism. I support the proposal. I have something to say in relation to declaration of prohibited places. Under paragraph 25, it says that under section 42 of the Ordinance, the Chief Executive may, by order published in the Gazette, declare a place situated in the SAR as a prohibited place if, having regard to the matters specified in a subsection, that the CE reasonably considers that it is necessary to do so. So how will members of the public know that it is a prohibited place? I have searched in Wikipedia the office of the office. There is a hotel. There is another hotel as the residence, another hotel as the headquarters, and another premises. So how will one know that the place of residence is a prohibited place and the office premises is a prohibited place? People do not pore over the Gazette, so how will they know? I ask this question because if people don't know about this fact, then they may inadvertently enter the place. They may want to approach the office for some other matters, and as a result, they go there. Is it the case that, well, when that happens, there will be criminal liability? Well, if someone walked past the Metro Park Hotel or the South Pacific Hotel, does it mean that they have broken the law? Secretary, it is not something new that the Chief Executive may declare a place as a prohibited places. Under public security orders, a public order ordinance, the CE may declare a place prohibited, say for example, Garrison Pier, where we will clearly specify the address, the coordinates. The coordinates will be a set of coordinates. The areas within the set of coordinates will be the prohibited place. We may not produce a map in the Gazette, but in the paper given to the LegCo, we will provide a map indicating the place that is to be declared as a prohibited place. I believe that they will be clearly indicated. It's just like other military restricted areas. There will be clear signposts erected to say so. Members of the public will not inadvertently enter the place. The prohibited places will be the entire building. So it won't be the case that the first to the third floor will be the premises of the office, whereas other floors are not. That is not the case. The entire building will be clearly signed as a prohibited place. Next, Mr. Dominic Lee. We need to keep improving our legislation to plug loopholes to national security. This is not just our duty, but it's also our aspiration. I support the proposal. I support the approach of negative vetting. The international situation is evolving rapidly. We need to plug the loophole as soon as possible. I see that in paragraphs 13 to 16, there is the citation of Article 55 and 57. It says that in certain cases, the office will take jurisdiction. Well, you may know about a litany of fraud cases. What if someone claims to be a staff member of the office, or if someone received a document purporting to be one from the office? How can the public verify the person's identity and the authenticity of the office? I believe that if there is a process that has been kick-started by the office in its investigation, they will not make it public. Secretary, if there is an investigation of cases under Article 55, I think it will be done in a confidential way. The details will not be publicized because that will not be reasonable. Of course, the office may make announcements as and when needed, but under the law, there is no requirements that the office should make an announcement that they are carrying out an investigation under Article 55. The member talked about deception cases. There are many deception cases in Hong Kong, some impersonating officers of public security, police officers, etc. We always tell members of the public that if someone approaches you claiming that they are public officers, the first thing you need to do is to be vigilant. There will not be a new risk because of the subsidiary legislation. So if you have doubts, you should contact the police. We have a very close communication mechanism with the office. So we will know about the situation. When the office exercises jurisdictions under Article 55, we have a duty to assist them. That includes crowd control, cordoning off certain places. These are part of our duties. Next, Ms. Eunice Yong. I support the making of subsidiary legislation for safeguarding national security. I think that this exercise is an important step to improve the safeguarding national security ordinance and regulations. I think the most important thing is to make things clear, and the fact that we fulfill our constitutional duty is important. When a piece of legislation is implemented, you need to make sure that there is an effective mechanism in place. I think under this exercise in relation to clarifying the roles of the committee, the office, the duties of various parties, I think we need to do our work well. We need to clarify the prohibited place. You need to make it clear what can or cannot be done at these places. It's important to let the public know. I agree that there is an urgency for the legislative exercise. There may be a lot of overseas spies operating in Hong Kong. We need to be forward-looking and legislate for these matters. It is equally important that we have to protect the public. Publicity and public education is also important for the public to understand. And I think it helps them identify espionage activities so that they will make a report to the police when they spot such activities. Different policy bureaus, including the Department of Justice, have been working to promote the national security law. We can draw reference from what we did in Article 23. We have done a lot of explaining. Some efforts are more targeted. Some take the form of a sharing session. We're undergoing a communication stage. We will listen to different views, and even when we have the subsidiary legislation, we will continue with our work. That is part of education for national security. We will make use of different ways to enhance understanding. We will identify ways to make it easier for the public to understand. We will stick to the same principle and the same approach. Next, Mr. Tenkapiu. Well, this is the making of subsidiary legislation for safeguarding national security. The Secretary for Justice has made some important points. There is no additional powers conferred to the office. This is just to clarify and clearly provide for the functions and work and implementation of relevant matters. One of which is that when the office needs assistance in the performance of their duties, then such assistance should be provided. There are law enforcement agencies such as the SFC, the Securities and Futures Commission, as well as the ICAC. They require assistance too. I think that is a similar power. It is something that we have been practicing. The exercise should be done as soon as possible. We should not be complacent. We have all gone through black lab violence in 2019. We have a very vivid impression of the cases under Article 55. Article 55 of the National Security talks about specific circumstances. It says that all departments, agencies, and public servants of the Hong Kong SAR should support the work of the office upon request. What if it's not just public servant, but public officers? Wouldn't that term will be better? Instead of saying public servants, shouldn't it say public officers? Under 8(3) of the under safeguarding national security, it says that if there is any functions conferred by the national security law that includes a duty to safeguard national security, well, there are some public bodies that are conferred such functions. If that is the case, then they will have to carry on the work accordingly.
Madam Chair, I'd like to ask a supplementary question because Para 15 talks about any public servants. So it's not just civil servants, but also any public officers, right? Yes, other than civil servants, well, under the laws of the SAR, anybody who is discharging duties conferred upon him by the law would also have to comply with this. Priscilla Leung, I welcome the administration in coming up with this subsidiary legislation which clarifies that when the office discharges certain duties under the law, then there would also be a division of labor and also the roles to be played by respective bodies. In fact, in 2020 and 2024, when we enacted the SNSO and also the Article 23 legislation, in fact, we have two sets of legislation and also two sets of system at play. And therefore, in coming up with this piece of subsidiary legislation, it does not increase the powers of the office. In fact, that's also a manifestation of the rule of law. It's also a manifestation of the respect for the one country, two systems principle, because national security law is a nationwide law, and it's also applicable to Hong Kong, and therefore it also enjoys certain powers under the Constitution. But then to ensure that Hong Kong people will find it easier to understand certain parts of it, we are trying to clarify it by coming up with express provisions. I think that is a very good way. In Para 10, Para 19, and also Para 23, certain legal issues are set out. And I'm pleased to see that anybody who works with the office in discharging its duties and functions, then he or she will be required to provide certain documents or other information. Then he will enjoy this immunity or civil immunity under the law. So I think that's a manifestation of the rule of law. And Para 19 also says that anybody without reasonable excuse, if you are aware that the office is now discharging its duty, and therefore there is no reason why you should disclose such matters to others. In fact, even without this, the office would already enjoy this power to discharge its duty. And also, in declaring a place a prohibited place, well, the central authorities also have its offices in Hong Kong, like the liaison office and so on. So everybody would understand that within its premises, that would be prohibited for entry. And therefore, in this case, we are just trying to make sure that you should not try to get close to such premises. And therefore, by adopting this negative vetting approach, I think we are very familiar with that because many pieces of legislation are also enacted by negative vetting, and therefore I don't think it's a problem at all. But then can you also clarify a bit further on Para 17 on the immunity from civil liability for any agency or person? So can you explain a bit further on that? Well, when the office publishes any legal documents, and if anybody does not have reasonable excuse, and if he or she fails to comply with the legal documents, then there would be a legal liability. But then if there are certain records which the office think that would be very useful in undertaking investigation, and therefore the office would declare that those documents would be subject to protection under the law. But then for the non-disclosure provision, given the fact that those are legal documents issued or published by the office, and therefore the person will have to act in accordance with the legal documentation, and therefore if he discloses such information in accordance with that, then he will not have to worry about incurring civil liability. So those are the circumstances that we are referring to in that paragraph. Thank you. Next, Ms. Doreen Kong. Thank you, Madam Chair. I have two questions. First, under Article 4 of the NSL and also under the SNSO, Article 2, they specifically provide that we will have to respect and protect human rights, and we will also have to ensure that Hong Kong people would be able to enjoy the rights under the ICCPR and also the ISGRA, because those would be the freedoms and rights guaranteed to us under the relevant legislation. So I'd like to ask the Secretary whether or not you'll be able to comply with the basic law and also the safeguards under the two international conventions. Second question, in paragraph 15, it says that in the subsidiary legislation, the ACR government will provide that in order to ensure that the office will be able to perform its mandate under Article 55, all persons will have to provide all necessary and reasonable assistance, facilitation, support, backing, and protection in accordance with the law and in a timely manner. So can you specify as to what would constitute all necessary and reasonable assistance, etc., etc.? Well, I'll answer the first question, and then for the second, I'll see if the Secretary can assist. Human rights are something that we attach a lot of importance to, so it's not just about the basic law. And in fact, under these SNSO, you can also find provisions that clearly provide that all the international conventions would continue to apply to Hong Kong, and therefore human rights would be properly protected. So on this occasion, we are enacting supplementary legislation, and therefore it must not be in conflict with the principal legislation. And therefore, given the fact that in the principal legislation, under the NSL and even the basic law, there are already overarching provisions safeguarding human rights, and therefore there is no question that we would not respect such rights under the law, and therefore any provisions concerning human rights would not be affected whatsoever under the proposed subsidiary legislation. Secondly, on reasonable acts. So under Article 114 of the NSL, any public officers in discharging their duties and also agencies and organizations responsible for national security, including the office and committee, they will have to be given all necessary and reasonable assistance, facilitation, support, backing, and protection in accordance with the law and in a timely manner. Well, reasonable appears in many provisions. So the reasonableness, proportionality, and also reasonableness and whether or not is lawful, and also whether it's executable. So these are the basket of factors that will be considered. Thank you. Well, it's my turn. I remember last year when we scrutinized this national security law and also the SNSO, we emphasized a lot that we will have to ensure that there will be complete conversion, and they should also be complementing one another. They should also be complementing each other, and therefore that's the reason why we have this Article 110, so that we can come up with subsidiary legislation. And also Chapter 2 of the Basic Law would also set out the duties of the office, and therefore for the office to discharge its functions effectively, that's also part of our safeguarding national security, and that explains why in the course of implementation we would also have to gazette the legislation before we can enable it to come into force. And also paragraph 17 also talk about the immunity to civil liability. I think that's very important to enable the office to deal with certain legal documentation, and also for the office to discharge its duties in good faith. Then the persons involved should be free from or should be exempted from civil liability, because the office would also have to publish legal documentation, and that would only be done under very rare circumstances under Article 55. And still, can you also provide something in writing with regard to this civil liability immunity, so that public officers will be able to discharge their duties to comply with the officer's instruction without any worries or concerns? And also, I'd like to set out a scenario, because it says that when somebody has to work with the office so that when he receives certain legal documents and then he will have to take action in compliance with that document. For example, that person would also have to go to the mainland in order to carry out investigation on behalf of the office. But then after he comes back, he finds that the documents that he submits to the office might be false or misleading. Well, that is not done intentionally. So he only finds out afterwards that the documents are false or misleading. Then with regard to the documents that are not in compliance with the law, then would that person be committing an offense? In other words, would there be extraterritoriality under the law? That it applies to anybody, including public officers. So the civil liability would not rule out public officers who are discharging their duties. And the second consideration is that if somebody, under Article 55, he might be obtaining information from the mainland, which might be false and misleading, and so on. So after he comes back, if he's free from or if he's exempted from civil liability, then would that become a loophole? So we will have to consider that very carefully before we can come up with the way forward. Next, Mr. Kennedy Wong. Well, today we're discussing this subject of safeguarding national security. Inevitably, that would bring me back to 2019 because at the time there were riots everywhere in Hong Kong. And today we are enjoying this situation of stability, and we can say that we can have tourism everywhere. And I'm sure the public would be very grateful to the central authorities because on the 30th of June 2020, the central authorities promulgated the national security law in Hong Kong, and that helped Hong Kong in restoring this stability. And 5 years down the road, now we are discussing how we can ensure that the office which will be executing its duties under the law as to how it should perform its mandate, so that certain places in Hong Kong should also be protected for the purpose of the office to discharge its duties. I would be very supportive of that. And therefore today, what I'd like to ask the administration is, we just received a paper, and then para 21 says that in the subsidiary legislation there should be provision setting out that the office in issuing identification document or document of certification for public officers. It should be effective. I understand that that would be necessary because that would ensure that the office will be able to discharge its duty under Article 60 of the HKNSL. But then are there any similar provisions under other pieces of legislation to achieve the same purpose? Secretary for Security. Indeed, yes. Under the garrison law, we do have similar provisions. Section 25 provides that, in the judiciary of Hong Kong, for the Hong Kong garrison discharging their duties as a Hong Kong garrison, then the documentation issued by the garrison would also be deemed lawful and effective. Next, Holden Chow. Thank you, Madam Chair. First of all, I'd like to say that I support the NSL as well as its subsidiary legislation. I also understand that Article 55 of the NSL spells out the mandate of the office and also the way it should discharge its duties. We can see that geopolitics have posed a lot of risk to our country. And earlier on, I also heard that the CIA of the US also announced that it would be recruiting Chinese all over the world to become their agents, and therefore you can see that geopolitics are posing a lot of risk to our country, and therefore we will have to take it very seriously, and sometimes we might have to resort to very extreme means in order to tackle the problem. In a paper, para 16 says that in accordance with Article 57, if the office issues certain documents to institutions, organizations, and individuals to comply with, and if there is no reasonable excuse, then the concerned parties might be committing an offense. So I'd like to know what is deemed to be reasonable excuse. For example, if you look at Hong Kong's laws, after you have been served a document, then the reasonable defense would be readily understood by everyone. But then after all, we are talking about the office and also is the NSL, and therefore we will have to refer to the laws of our country in interpreting this. So can you tell us exactly what the basis of reasonable excuse is, and what does it entail? And also for the office to discharge its duty, we do have confidence in it. But then, as many members have said, people or illicit elements might be impersonating the staff of the office, and they might be issuing falsified legal documents. And if someone is to verify whether or not the legal documents are authentic, and then could that also become a reasonable excuse? Because they would also have to verify the authenticity of the document in order not to allow somebody to falsify any documents.
Shall we hear from the Secretary for Security? I'll start first. First, in relation whether someone is impersonating a person. Well, we have a lot of deception cases in Hong Kong, in particular, perpetrators impersonating police officers or officers of public security. We often remind members of the public that, if necessary, they can report to the police. We have an established mechanism with the office. We can quickly clarify the matter. Now I turn to reasonable excuse. It depends on the situation. Let me just give you some examples. If it's someone who can't read Chinese and receives a document in Chinese, or if the English version is somewhere else, then the person may not be able to comply. And if the information is in a computer and the computer breaks down and needs repairing. And a third example is that when a report has been made to the police, and will you say that I have not complied with the document in just a few minutes after I've made the report? I think whether there is reasonable excuse depends on the actual situation. Next, Mr. Dennis Leung. After the reunification in 1997, we have one country, two systems under the Basic Law. The way of life in Hong Kong remains unchanged. Hong Kong continues to be a free port. There is free movement of Hong Kong people. But because of these freedoms, well, Hong Kong is a center for intelligence to change hands. What happened in 2019 proves that these things do happen. Without the National Security Law or the Safeguarding National Security Ordinance, then we will not have effective means to stop these acts or prevent the risks. Well, under Article 60 of the National Security Law, it stipulates that the acts of the office and its staff members in the performance of their duties is not under the jurisdiction of the Hong Kong SAR. Does it cover power of arrests, investigations, etc.? The National Security Law also empowers the office to produce identity documents and certifications to prove the identity of their officers. Well, the Secretary said that there are many fraudsters in Hong Kong. They impersonate staff members of the office to get money or to do other illicit acts. So how can someone differentiate fraudsters from genuine officers of the office? This will help the performance of duties of the office and staff members. There are two questions. Secretary. Article 60 of the National Security Law states very clearly that acts performed in the course of duty by the office and its staff members shall not be subject to the jurisdiction of the Hong Kong SAR. In relation to issuance of documents, well, there are similar examples. One is under the garrison law. The proof itself is evidence. And it proves the identity of the person in the execution of their duties. There are deception cases in which people impersonate officers of law enforcement agencies, be it police officers, customs and excise officers. We always tell the public that when in doubt, call the police. Next, Mr. Chen Siu-hong. I myself, chairperson, and a number of members have taken part in the Bills Committee of the Safeguarding National Security Bill. In relation to Section 110, that is, the Chief Executive in Council may make subsidiary legislation on implementation details to better improve the implementation of national security matters. We talk about a complicated global situation. When it comes to our legislative exercise, I think the earlier the better, so I support it. Well, I have 3 questions to ask, one of which is in relation to impersonation. Somebody has already been asked. I now have 2 questions. First, in relation to paragraphs 25 and 26, Declaration of Prohibited Places. The Secretary explained that these places include the actual office premises of the Office for Safeguarding National Security. There will be coordinates provided. When it comes to premises where the office performs its mandate, it's not just the office building. What about the scene of crime where evidence is collected? Will the CE in Council declare that the scene will be a prohibited place for, say, 3 days? If that is the case, it's very complicated because it may involve one floor or a certain section of a commercial building. How would you deal with it? In paragraph 24, I see that the government proposes to add as a matter of principle the obligation to keep confidential the work-related information in connection with the office. Why is it a provision to stipulate as a matter of principle? Why isn't it the case that, well, if you do not do this, then it's an offense? In general, if it is a matter of principle, then there won't be any penalty. In addition to making it a matter of principle, will you also set out the penalty? I'll answer the first part of the question, and the Secretary for Justice will answer the other part. We talk about fraudsters, imposters, and if someone impersonates a staff member of the office, it is an offense. The question about prohibited places. Well, when an investigation is carried out at a certain place, will it be declared a prohibited place? You need to first understand what is meant by a prohibited place. If it is an office premises of the office and someone enters to carry out sabotage or espionage activities, then it will pose huge risks to the work of the office. That's why we need to designate or declare the office premises as prohibited places to accord better protection. And the member talked about a place where an investigation takes place, these are two different concepts. When an investigation is carried out, as I said, law enforcement agencies will have the duty to provide assistance. There is no need to make subsidiary legislation asking the chief executive to give an approval to declare a certain location. It is not in line with our objective. The objective of a prohibited place is to bar unauthorized entry, say for example a spy going in to carry out espionage activities. This is very different from a place where an investigation is carried out. Secretary for Justice. Well, under common law, there is no clear definition. First, we have to clarify the obligation of confidentiality. But there are exceptions, say when the information is already made public. We have to first of all state the obligation to keep the information confidential. It may be a matter of principle, but it doesn't mean that it is unclear. There will be a clear elaboration of the duty. We will make it very clear in the provision. Next, Ms. Maggie Chen. I support the making of subsidiary legislation. There is robust constitutional basis, and we have local and national legal basis. The subsidiary legislation is within the scope of the principal legislation. It's only about setting out implementation details. This is fully in line with the legal spirit and principle. Institutions and individuals in Hong Kong will have a better understanding of the implementation details of the law. In Chapter 5 of the National Security Law, you will find the mandate of the office. When the office carries out these duties, is stated under Article 61 that individuals and organizations should provide assistance. Is there a reasonable excuse to not provide facilitation? This is in line with a common law jurisdiction. Well, as to whether it is done in good faith, there is also a reasonable excuse. In relation to confidential obligation, well, I see that there is an obligation of confidentiality. Article 63 talks about keeping the investigation and related information confidential. But in Hong Kong, we have rights to litigation. So I would like to get clarifications from the two secretaries. How does one interpret the confidentiality clause on the part of lawyers in handling litigations?
Secretary, Well, I think we can only talk about it as matters of principle. For example, so we will have to look at the kind of duty that is being discharged by the office. So let's say it's not something under Article 55. Let's say I have to consult legal advice on certain matters. Then in accordance with the laws of Hong Kong, well, generally speaking, so the common law dictates that there would also be certain safeguards, and that would have nothing to do with the supplementary legislation that we are talking about. Once Article 55 is invoked, you can also make reference to Article 57. So you will have to look at the criminal law of the PRC. And Article 58 also says that in the extreme situation where such laws have to be invoked, then for the person, if he believes that if there is when he first receives inquiry made by the office, then he can ask a defense lawyer to provide legal assistance in accordance with the law. So that's in accordance with the mainland legislation. Then the suspect would also have to be protected in accordance with the law, and therefore the right to defense would also be fully respected. Okay, Ms. Chen. So can the Secretary also confirm that very often in Hong Kong, when it comes to our own jurisdiction, a lawyer represents his clients, and there would also be certain legal indemnity or privilege. And relatively speaking, I don't have to disclose to the authorities without invoking Article 5 of the relevant legislation. So if it's a relationship between the lawyer and his client, then under the basic law, that would also be part of the protections or safeguards with regard to legal privilege. So that would not affect a person's rights under the basic law, his human rights, including the right to consult legal opinion, and also certain privilege as what we call it. That is, the lawyer would also have to protect his client's interests. But then under the new legislation, so when it comes to the work of the office, anything that we are not supposed to disclose. So we are not supposed to disclose the information that is in the hands of the office. Okay, so that's clear. So it doesn't affect the communication between the lawyer and his client. So when the client consults a lawyer on his legal rights, then that would still be protected. Next, Mr. Chow Min Kwang, I support the Security Bureau and also the DOJ in coming up with the subsidiary legislation under the NSL, because that's in response to the legislation enacted a year ago. Is a well thought out subsidiary legislation, because we need to have this mechanism in place in order to better safeguard national security, and it provides further details to the NSL, so that for those who intend to endanger national security, we are sending out a very important message to that and to them, and therefore it should be supported. So we will need to invoke legislation in order to protect national security as well as the life and limbs of our nationals. So definitely it would only affect the big tigers, and for those common people, they would not be affected whatsoever, and it's only targeting very serious and egregious cases with significant impact. So both the Secretary for Security and the Secretary for Justice have already explained that very clearly. So the important thing is, how do we explain that very clearly to the public, because it's there to protect their rights, so that the public would also have to know more clearly. I remember 2015 there was a movie, and Jackie Chan and also Chiang Kai-fai played a role in that particular movie, and the movie says that there was there was a nuclear bomb coming to Hong Kong, and there were a lot of concerns and worries in the community. And in the movie, it says that the central authorities were involved, and the National Security Office was also involved. I think such movie clips would be very good, because it has to do with everyday life of our people. and therefore it's not just about politics, and therefore everybody can be affected. So we will have to think out ways in order to disseminate the information more effectively and widely. And also you talk about prohibited places. In fact, under the Garrison Law of Hong Kong, we also have similar provisions. And I think to set it out more clearly and expressly in the law, and that would enhance the transparency of the office so that people will not be caught by the wrong side of the law inadvertently. Thank you. Okay, Mr. Chow is suggesting that you should produce a clip to advertise that. Yes, we will have to explain to the public very clearly as to what it is about. In particular, we are now enacting subsidiary legislation. We don't want to see any misunderstanding, for example, on the issue of prohibited places. Well, you would not be caught inadvertently simply because you go to a place to work. So we will have to explain things more clearly to the public so that they would understand the scope of the law, and that would not exceed the scope of the principal legislation, and there would not be any new powers generated by the subsidiary legislation, and people will not be affected adversely. So the principal law and also the NSL as well as the SNSO, we will have to publicize them, and that is a continuous work. We will have to do it extensively to all sectors of the community, and the youth would also be the focus of our work. In fact, that has already become a subject under general science, and we might even have to go further in order to ensure that everybody would have a good understanding of that. Next, Mr. Edmund Wong. Yes, as according to my understanding, both the SNSO and also the NSL have already got provisions with regard to the mandate to be performed by the office. There should be protections and safeguards, including Article 61. It says that in accordance with the NSL, when the office performs its mandate, it should be facilitated and supported. So my question is, with regard to the subsidiary legislation for the purpose of the office to perform its mandate, are there any similarities between the subsidiary legislation and the principal legislation? And also, does it include providing priority to vehicles of the office and also its staff? And also, when they go to restricted areas, they would also have to provide free access or facilitation as well. And the third question is, you also refer to public officers when they discharge the duties, they would also have to provide support and facilitation to the office, for example, for the purpose of emergency rescue and so on. If they fail to provide facilitation to the office, would they be committing an offense? 3 questions altogether. Well, let me try and answer the questions first. You talk about some staff of the office when they are discharging their duties, and if public officers are not able to provide immediate support to the office, would that be an offense? For example, for fire officers putting out a fire, well, if they are not able to provide immediate support to the office, would that constitute an offense? Well, I think it all has to do with reasonableness, and therefore we all have to adopt common sense and reasonable interpretation to this, and that would also constitute a reasonable defense. And can you, well, some examples have been given. I think they are all very suitable examples. For example, let's say for a public officer discharging his duty, then when there is a vehicle from the office trying to gain access to a certain place, should they be given facilitation and so on? Well, on the face of it, it appears to be very reasonable support. And of course, we cannot possibly provide an exhaustive list as to what has to be done in a particular situation. But then if you can give some examples, and then if that could be used to illustrate what needs to be done in the law, then that would also be helpful. Well, can I take the opportunity to answer the question? I think the core of the question is about why do we need to have additional supplementary legislation, given the fact that we have already got Article 61? Well, to use the earlier example, well, in accordance with Article 61, we will have to provide necessary support and facilitation. So is it an absolute obligation? For example, if there is a reasonable excuse, it's not that I don't want to do it, it's that I cannot do it. Then would that constitute a reasonable defense? We will have to spell it out more clearly. And also, in obstructing certain duty to be discharged, we will have to go after the person for their duty and so on. Does it mean that he will have to be penalized by being sent to prison, or does he have to pay a fine? Would there be reasonable defense? In fact, Article 61 has not spelled that out very clearly, and therefore it's not just about defining the duty. We will also have to set out the liability and also the defense that could be put forth by the defendant. So I think the public would also have this reasonable expectation that we would spell everything out very clearly. That's the reason why we need to have this subsidiary legislation. Can I ask a supplementary question? Well, just now you also talk about priority of leaving or coming into Hong Kong. So do we have to provide or give priority to vehicles of the office? I think that would depend on the urgency. Mr. Ma Fong Kwok. Thank you, Madam Chair. National security is undoubtedly very important, and therefore, well, because we didn't have national security legislation for 20 years, that's the reason why we had the riots and chaos in 2019, and subsequently, after the NPCSC promulgated the national security law, we then have been able to enjoy peace and stability. So it shows that the NSL is there to protect us, and the subsidiary legislation is a very important part of implementing it, and therefore we need it absolutely. And with regard to the legislative timetable, we hope to be able to have the legislation early. The sooner, the better. So that's the way we think about it. Well, on the 23rd of March last year, we had the national security law formally promulgated. It's been a year now. So why have we not been able to introduce such subsidiary legislation earlier in order to perfect the law? So can you explain to us what are the difficulties that you have encountered in the course of drafting the legislation? Are there any other considerations resulting in the late tabling of the legislation? Secondly, well, in implementing the national security law, it's been some time now, so have you encountered any circumstances in which, because of the lack of such subsidiary legislation, it has given rise to certain enforcement difficulties or obstacles? Have you encountered any problems? And finally, it's my opinion, because in order to avoid a situation whereby there might be misunderstanding or people might try to play up certain matters. So can you come up with more detailed and clear explanations in your publicity work? So, Security Secretary, why now and why not earlier? Well, you might have waited for a long time now. But first of all, last year in March, when we enacted the legislation, and it takes some time for us to observe how the law is being implemented, and we would also have to rationalize things and sort out where we need to have more detailed legislation. So in which area do we need to have more detailed legislation, and which are the problematic areas that we need to resolve? But then the reason is that, of course, the sooner the better. We hope to perfect the system, and we hope that everything can be reasonable, and we will need to spend some time on the details to be sorted out. And also, we will also have to finalize some of the details of the offences. And once we are ready, we will come back. And also, you asked whether or not there have been situations whereby, because of the lack of subsidiary legislation, there might have been problems. Well, up till now, we haven't got the situation under Article 52, and therefore, we have not been affected because of the lack of subsidiary legislation under Article 55. I have to emphasize that Article 55 is about very serious and egregious situations. We don't want that to happen. We hope that it will not happen in the future. But then we will have to be preemptive in order to ensure that nothing untoward will happen in the future. Thank you. Next, Mr. Tang Fei. Well, at the start of the meeting, about an hour ago, well, my office and also the National Council also announced the white paper on national security, and that's just published. And therefore, I think today's meeting is in line with our country's policy, and therefore it's commendable. But then I still have some concerns. So I don't know if I have interpreted it correctly. I'm sure many members of the public would also share my sentiments. That is, to have this subsidiary legislation is to ensure that the office in performing its mandate in Hong Kong, in particular, when it comes to enforcing the 3 duties under Article 55, they will be able to invoke local legislation to facilitate its work, and the provisions would also be clearer for the public to understand. That is, without the subsidiary legislation, if we only have Article 55, it's a bit too abstract, and therefore, with the subsidiary legislation in place, it has not changed the principal legislation. In fact, it would be more reassuring to the public because they will know for sure as to what will happen. So that's my interpretation. So is that correct?
My second question. Well, you have not made changes to the principal legislation in relation to duties and rights. If someone without authorization engage in activities endangering national security in premises of the office, what will happen? Because we can't rule out that possibility. If an act that endangers national security in a prohibited place, but if the act does not fall under the 3 circumstances set out under Article 55, does it mean it's under the jurisdiction of Hong Kong SAR? And if the act involves either of the 3 one of the 3 circumstances set out in Article 55, then the office will exercise jurisdiction. I just want to clarify. Secretary for Security. Mr. Tang has made a very good point. I'd like to take the opportunity to clarify. Under Article 55, there are 3 circumstances. In short, that the situation is complex, serious, and the circumstances cover the 4 offenses, that is, succession, subversion, terrorist activities, and collusion with foreign elements. If it is in relation to, say, resisting or obstruction, offenses that stem from local legislation, then local law enforcement agency will exercise jurisdiction. The office will only exercise jurisdictions in cases involving the 3 special circumstances involving the 4 serious offenses. Article 42 is in relation to declaration of prohibited places. If there is espionage or unauthorized entry, then they fall under the scope of the subsidiary legislation. The case will be handled by Hong Kong Law Enforcement Agency because these offenses are not the 4 specified offenses under the national security law. Well, if someone commits theft at the same time as a succession, then the 2 cases will be handled separately. The office will only handle cases involving the 4 types of offenses. So even if it involves a prohibited place, then is under the scope of the subsidiary legislation and handled by Hong Kong Law Enforcement Agency. It will not be under the jurisdiction of the Office of Safeguarding National Security. I think we do need to clarify that. Mr. Lo Wai Kok. Last year, we enacted the Safeguarding National Security Ordinance under Article 23. I was one of the members in the Bills Committee. It was gazetted on the 23rd of March last year. We fully understand even back then that there would be follow-up legislative work. Section 110 of the Ordinance clearly stipulates that the Chief Executive in Council is empowered to make subsidiary legislation. It is of a similar structure and procedure of other legislations. This is nothing surprising. I want to say that Article 40 of the National Security Law sets out the clear jurisdiction of the Hong Kong SAR over cases. Article 55 specified special circumstances, namely, when the Hong Kong SAR cannot effectively enforce the national security law, when there is involvement of foreign country or external elements, or when there is a major and imminent threat to national security. It is only under these circumstances that the office will exercise jurisdiction. Of course, as to how it is actually handled, it involves details. It will be provided for by way of subsidiary legislation. That is only natural. I support the legislative exercise. We should lose no time. No one can predict when there is a risk of national security. We need to be fully prepared as soon as possible. Declaration of prohibited places. That is also natural. There is another piece of legislation not directly related to national security. It is an amendment to the Building Energy Efficiency Bill. There is this scenario. If, in relation to a certain government premises, that the head of a department says that because for national security reasons, it is not appropriate to conduct an energy audit of that building. So, well, my understanding of the situation is that there are certain procedures that do not apply for certain reasons in relation to some premises. And this is the matter under the Building Energy Efficiency Bill has been dealt with. Security Secretary, I think you are talking about the National Security Ordinance, nothing to do with the Office for Safeguarding National Security. Ms. Elizabeth Quat, without national security, we won't have stability. Without national security law, it is impossible for us to revive our economy. Because what happened in 2019 would continue. The national security law is of utmost importance to the prosperity and stability of Hong Kong. There is nothing new in this legislative exercise. They are provisions already in the national security law. We have the duty to continue to improve the ordinance and the national security law to effectively prevent, suppress, and impose punishment of offenses that endanger national security. It is not a piece of new legislation. They are subsidiary legislation to support the implementation of the national security law and the ordinance. If we do this earlier, the better. This is very important. As the Secretary said, that incidents that endanger national security or acts that endanger national security can happen any time. We need to prepare in advance. The government proposes an offense that is in relation to willfully resisting or obstructing the office in the performance of a duty and willfully resisting and obstructing others in assisting the office. Well, there is a citation of the Offences Against the Persons Ordinance, Section 36. It's in relation to obstructing public officer in the performance of a public duty. It also covers assault on such a public officer. Will you consider making it an offense covering assault on such officers? Of course, an assault is obviously an obstruction. It will be reflected in the penalty. Well, let me say that whoever is assaulted, whether it's a public officer or not, is a criminal offense. Here, we're not talking about not necessarily the violent attack. It's about obstructing and resisting. Article 61 is about obstruction. So that is the focus. But it doesn't mean that if you assault an officer of the office, then you are absolved of the law. That is not the case, because assault is a criminal offense under the law. Mr. Stanley Ng, we have to continuously improve the laws and mechanisms in the implementation of national security matters. Section 110 of the Safeguarding National Security Ordinance clearly stipulates that the Chief Executive in Council is empowered to make subsidiary legislation. The subsidiary legislation cannot increase or detract anything in the principal legislation. I'm sure that the Department of Justice and the Security Bureau are very careful in the making of the subsidiary legislation. We have to objectively improve it without adding or deleting anything. But subjectively, is it the case that it is undermining the original legislation in terms of its functions? It talks about exceptions and exemptions. Is the National Security Law and the Safeguarding National Security Ordinance included in the subsidiary legislation? I myself and the Secretary for Justice said that subsidiary legislation stems from the principal legislation. There is no addition of powers. And there is no reduction of powers in the principal legislation. The subsidiary legislation is to provide for implementation details and offenses as well as penalties. Secretary for Justice. Well, the objective of the subsidiary legislation under Section 110 is for effective implementation details. So it cannot be done by reducing the powers of the office. Then of course we have to clarify the implementation details and to let the public know more clearly what they need to do. I think the objective of the subsidiary legislation is for effective implementation of the law. From the paper of the Department of Justice, there is the mention about immunity of civil liability. Is there any chance that there is a reduction? The purpose of the immunity is so that individuals and organizations can support the work of the office without having to worry. The office, in accordance with the law, may issue legal documents, make requests of a third party to provide information. Well, the person may think, well, I have to comply with the request, but we as a bank, under the common law jurisdiction and contract law, I have the duty to keep a client's information confidential. Then the bank will be in a dilemma. Should I comply with the request of the office, or should I keep the information confidential? The immunity to civil liability gives the reassurance that the individual and the organization will not be pursued civil liability for complying with the request of the office. This is for more effective performance of duty on the part of the office. That is the spirit of the immunity.
All right, the Secretary has already explained that. Para 17 also says that, under Cap 200, and also you have this, and also there is some Section 380 under Cap 571, giving examples as to how civil liability can be exempted. Mr. Paul Chair. Well, the NSL was drafted by the mainland, and therefore in Hong Kong we practice the common law, and therefore we have our own practices and traditions, and therefore to clarify that by way of subsidiary legislation is to be welcome, and that would also enable us to implement the NSL more effectively, and that's the purpose of the subsidiary legislation. And of course, there is no retrospective power under the law. And given the fact that we enacted the NSL on the 23rd of March last year, so if circumstances under Article 55 have arisen, then we could have made a referral. So now we are clarifying that position under the subsidiary legislation. Well, under Article 55, there are three circumstances, and the first two have to do with the situation in Hong Kong, for example, the involvement of a foreign country or external elements, and also a situation whereby the SAR government is unable to effectively enforce the law. But then the third scenario involves the country that is a major and imminent threat to national security has occurred. And according to the Secretary, well, you explained just now, as of now, we haven't seen any circumstances under Article 55 arising. And of course, we are pleased to see that. But then given that, does it mean that up till now, Article 55 does not have to be invoked because we haven't reached a situation whereby the three circumstances mentioned under Article 55 have arisen, and therefore none of the cases would have to be referred because of the subsidiary legislation, because some of the cases are pending and there are some situations that have happened. But then given the fact that we have not seen any locality-specific circumstances under Article 55 that have arisen, and also and therefore there is no need for us to refer the cases to the mainland for trial. And also Ms. Maggie Chen also asked about para 19 is about the client and the legal officer or the lawyer. So we don't have to repeat that. But then in para 19, well, I haven't got the draft wording here, but then para 19 apparently is about the duty to confidentiality, and apparently it applies to everyone. So other than the enforcement officer or lawyer, as mentioned by Ms. Maggie Chen, so anybody would have this duty to confidentiality. So I'd like to ask more about this anybody. So has that departed from what we refer to under Article 63 of the NSL? Those are the officers under Article 63. So anybody will be subject to this restriction. So other than the information under investigation, would that be like what the ICAC is doing? So that so long as a case file is open, then you would not be permitted to disclose anything, or else you'll be committing a criminal offense. If there is time, then I can ask one more question. If none, then I'll stop here. There is time. Okay, just now, we also asked about the ICCPR and ICESPR because it involves Article 14. It's about right of self-incrimination. That is, we would not be incriminating ourselves under that article. But then if you have to invoke Article 55, my understanding is that Article 15(7) would mean that the criminal law of the mainland would come into play, and therefore there is no question of protecting or safeguarding such rights under the international conventions. So on the overriding principle of safeguarding national security, and of course Article 55 refers to very serious cases, but then in the event that that should happen, does it mean that that would be taken away, and therefore your rights will no longer be protected under those international conventions? Well, your question is about retrospectiveness of the law. Well, under the SNSO and also the NSL, there is no retrospective power. So that's it. And therefore, before the enactment of the laws, any offense committed would not be dealt with under those two pieces of legislation. But then does it mean that before the coming into effect of the subsidiary legislation, we cannot go after the persons? Of course, that's not the case either, because given the fact that the NSL and the SNSO were already enacted before the subsidiary legislation, and therefore if there is any offense committed after the enactment of those two pieces of legislation, even without the subsidiary legislation, you will still be caught by the principal legislation. And also, if there is a pending case, then it's a continuous offense, and therefore we will still have the power to deal with such offenses. The second question is about disclosure of an ongoing investigation. So you gave an example just now, and it's also very appropriate. That is for the ICAC investigating a case, so the disclosure of such investigation would be an offense. So under the present law, if you disclose the information without authorization, then that would be an offense. And of course, what would constitute reasonable authorization would also have to be interpreted. Many people are very familiar with the two international conventions protecting human rights, such as self-incrimination. But then in the event that Article 55 is invoked, once it's invoked, then as you just said, the applicable laws will no longer be confined to that of Hong Kong, and therefore mainland laws would also apply, and the relevant legal principles, including the safeguards to the defendants, would also include the PRC's criminal law, and also the relevant criminal principles of the mainland would also apply. And I'm also not qualified to give you an authoritative interpretation, but then according to my limited understanding of the mainland laws, they may not have corresponding protection or safeguards as those in Hong Kong, but then for the presumption of innocence that you refer to, in other words, the defendant does not have to prove his or her own innocence, and there would also be this presumption of innocence. And my understanding is that the mainland laws also have these safeguards. But then for the specific details, you will have to refer to the relevant legislation on the mainland. But then, as I said, we have Article 58 of the NSL that is very important. That is, once Article 55 is invoked, then any suspect in the first interrogation, he can already ask a defense lawyer to provide legal assistance to this criminal suspect in accordance with the law. And I'm sure the criminal suspect has the legal right to appoint someone who is qualified in the mainland to represent him, so that he will be told his legal liabilities and obligations and so on. I think that would be the appropriate way to look at this. Okay, because of the time constraint, I can only allow for Mr. Lai Tong Kwok to ask his first round question. So thanks to your cooperation, we have been able to allow everybody to ask their first round of questions. Mr. Lai Tong Kwok. Thank you, Madam Chair. I speak in support of the government's paper today that it intends to enact subsidiary legislation for the purpose of safeguarding national security, and also to effectively implement the NSL as well as the SNSO. Well, many colleagues just now asked questions about this issue. So they have put questions to both the Secretary for Justice and Secretary for Security about this. And my understanding is that the two secretaries have given very clear answers to the questions. That is, the subsidiary legislation is enacted for the purpose of effectively implementing the existing legislation. It would not be reducing or increasing the pre-existing laws that are already enacted. Because the NSL was drafted in accordance with mainland legal principles, and therefore when compared to Hong Kong's common law system, in terms of the expressions, they may not be fully aligned with the common terms used in Hong Kong's common law system. And therefore, when we discussed and enacted the NSL, those principles were discussed, and now the administration has now come up with this proposed subsidiary legislation, and I believe that that would be for the purpose of implementing the two laws more effectively, and the areas that are mentioned in this paper, in my view, are also closely aligned with the requirements of the principal legislation, and they are moving in the correct directions. And of course, I haven't seen the substance of the subsidiary legislation, and I'm sure after we have seen the details, we will be able to have a better and more detailed understanding of what the administration is now proposing. Secondly, on the issue of prohibited places, well, as some colleagues have said, well, that would cover the office of the office. Would other places be covered as well? Well, if you look at Article 42, I believe that that is already very clear, because under NSL, Article 42(2), it specifically points to certain relevant matters under which you can designate a place as a prohibited place. You will also have to spell out the owner of the premises, and also the nature of the things that have to be safeguarded. So that has already very clearly spelled out as to the grounds for believing that those premises have to be designated prohibited places. Is not a haphazard or arbitrary decision. So that's definitely not the case. So the designation of prohibited places would be a usurpation of power. So that's my comment. Thank you. All right, I'll extend the meeting by 10 minutes to ensure that all questions can be raised, and then I'll allow the administration to summarize what has been said. Yes, thank you for your interpretation just now. I fully agree with that. That has spelled out the rationale behind the subsidiary legislation. Thank you very much. Okay, thank you for attending today's meeting. So, administration, do you have anything to add? If none, then we will move on to item 3 of the agenda. No, I have nothing to add. The only point that I'd like to make is that we'd like to express the fact that members have been able to understand our proposals within such a short space of time, and there are many things that we'd like to explain to the public, and therefore we are very grateful to members for their support. Thank you. Okay, item 3, AOB. I don't have any AOB here, and therefore I declare the meeting adjourned. Thank you.